Thank you very much, Justice Wiggins, members, ladies and gentlemen of the commission. I want to take a couple of minutes to introduce myself because I think I am unknown to most folks here, to give you a little bit of background and how I came to be sitting in front of you today. I grew up in Columbus, Indiana, so I'm a little bit different in that sense from most of the candidates. I went to Butler University in Indianapolis, majored in pharmacy, got a degree in pharmacy in 1981. And following that, I worked a number of jobs in different hospitals and community pharmacies in those few years after graduation. And during that time, gained a lot of real-world experience as far as managing people, doing budgets, purchasing, lots of kind of things that happen every day in a number of different businesses. So after a few years, I really started looking for a new challenge. And one of my customers was a lawyer who came into my store, and we were in a pharmacy that was in a grocery store. And so he would bring his wife in to shop, and while she was shopping, he would come over and talk to me. And so we had a number of interesting conversations about different topics. And so one day I said, "Do you think I could get into law school?" And he said, "Absolutely." And so I applied to law school and at Indianapolis, Indiana University in Indianapolis, and started in their evening division. So they had a full-time day program as well as the evening division. So during that time, I was working full-time, going to school at night, juggling family and kids and all of those kind of things. And obviously, at that time, I didn't do that alone. My wife did a lot on the home front to enable me to go off and do those things. And was on the Indiana Law Review, did some editing there. Unfortunately, my paper didn't get published, but I was on the Law Review. And at the end, in 1993, graduated in the top 8% of my class. And the way that we did our classes there, they mixed the daytime students with the part-time students. So everybody graduating in 93 was put together, so it wasn't separated. So I'm pretty proud of that accomplishment, I think, going against some of the younger students who had a lot more time to work on the studies than I had. So in 1993 in Indiana, I don't know what it was like here in Iowa, but it was a very bad job market. And a number of law review members came out of school with no job offers. And I was one of those. And so after a time of failed interviews and no jobs, I decided I would break out on my own and open my own practice. So I did that in Danville, Indiana, which is where I was working in the hospital pharmacy. And that was a great learning experience. Obviously, if you're out there on your own, you have to learn, kind of hit the ground running and so on. But unfortunately, I, as I like to say, overestimated my client base and underestimated my expenses. So that turned out not to be a great thing in the long run. But it did teach me a lot. So in 1998, I joined Pharmacists Mutual Insurance Company up in Algona. And the primary move there was the fact that I could use the pharmacy background with the legal background. And their primary market is pharmacies and pharmacists. So in those 12 and a half years, my primary job has been to handle professional liability cases. So in that job, I work with our outside counsel, evaluate cases, decide which ones we're going to try, which ones we're going to settle, and all of those kind of things. In 2001, I became involved on the corporate side and started working with our company's legal needs, employment law, real estate transactions, contracts, just about anything that you can imagine that a company would need. In 2005, when my predecessor moved on to greener pastures, then I became general counsel of Pharmacists Mutual as well as the Pharmacist Life Insurance Company, which is one of our subsidiaries. In 2004, in September of 2004, I was admitted to the Iowa Bar. When I took the job with Pharmacists Mutual, I came up 2 months short of having 5 years of practice in Indiana, so I couldn't waive in, unfortunately. So at age 46, I did what most lawyers would never want to do, which was take the bar exam again. And passed and was admitted in September of 2004. And then shortly thereafter, they changed the rules for corporate lawyers. And had I waited a couple more years, I could have waived in with 5 years of registration. But in the long run, it was a great thing to do. Obviously, took some time and effort on my part, and I'm very proud that I've done that as well. So why am I here today? Comes down to the retention vote in November of 2010. It was really a fear of mine that there would be no applicants, that we would have no qualified people stepping forward to fill these positions. And so I just decided that that was something that I couldn't let happen, and decided that I would put my name in and see what happens. Now, obviously, my fear was unfounded when you look at the list of people who have applied. There's lots of quality people on there. And so now we're just back to business as normal, so to speak, with that slate of candidates. As part of that retention vote, obviously, the electorate has the need and the right to be informed. And so I'm not sure that we really had a two-handed or an even provision of information to the electorate. And in the Code of Judicial Conduct, justices are allowed to campaign, so to speak, to retain their seats. And I think that really needs to be done in 2012 to balance the playing field. And obviously, in the end, the people get to vote and the people decide, but they do need, I think, to have full information to make an informed choice. So what do I bring? I bring a lot of real-world experience, working in businesses, and those are the kinds of things that cause lawsuits to be filed and cases to be heard. We get involved in the legal world, and we start talking about cases as supporting a proposition, or this case stands for this, or this case stands for that. But in the end, there are disputes between everyday people about important things in their lives. And so we really need to keep that in mind. And so the decisions from courts are not just affecting those parties, but they affect everyone. And so I think that real-world experience that I have will help in looking at those cases. Looking at my biography, as you see there, I've taken on a number of challenges. I've had people around me say, "Why are you doing that? You're completely crazy for trying that." And I've been able to succeed. And I don't see any reason that I can't succeed here. My experience at Pharmacist Mutual, a lot of insurance it's contract law, basically. But it's very similar to the kind of analysis that goes into cases. You get a claim in, you look at the facts, what happened, and then you look at the contract, the policy, and then you apply the facts to that policy. And so I think you see a similar kind of analysis with cases and case law. So with that, I will, if I'm given the privilege of serving on the court, obviously I will serve with all the energy and integrity and diligence that's required of the job, and the same energy, integrity, and diligence that I've given to every other job that I've had. Thank you very much.
Thank you, Mr. McGuire. Any questions to my left here?
Take one.
Go ahead, Ms.
Mr. McGuire, what do you believe are the strengths and the weaknesses of the Supreme Court, and what, if any, changes would you make?
The Supreme Court as it is today, you mean? I don't know that there's any weaknesses. If you look at the state of Iowa, it's well respected in the country. With our company, we do business in 49 states, and so I've had some experience with a lot of other court systems. And the Iowa system consistently ranks in the top 5, if not the top 10, depending on who's doing the ranking. I don't know that there's a whole lot that I would fix at this point.
Mr. Holm?
Good morning, Mr. McGuire. Some people have suggested that the Supreme Court needs to make increased efforts at public outreach. I'm wondering if you have any ideas, specific ideas about how the court could increase its contact and outreach with the public of the state of Iowa.
That's a good question. I've been to a number of meetings, Iowa Defense Council and those kind of things, and justices do come to those meetings and speak, but it's not reaching the public at that point. And I think that you could do something like that. And I haven't given a lot of thought to specifics, but I think there's numerous occasions where the judges, the justices could be more out, if you so to speak. The State Bar Association always has a booth at the state fair, for instance, and lawyers volunteer to come there and talk about different things. I don't see any reason that a judge or a justice couldn't be at the booth at the state fair with the Iowa State Bar.
Any other questions to my left here? Mr. Cook?
Thank you, Justice Wiggins. Is your pharmacy license still in good standing?
It is. I have a pharmacy license in Indiana and Iowa, and a law license in Indiana and Iowa.
To what extent do you think that to be a judge, the person should have a wide variety of legal experiences?
Well, I think it depends on the judicial position that you're talking about. A trial court judge is much different, I think, than an appellate judge. Trial court judge is obviously, guiding the case, the trial as it goes on, and so you have to have a really intimate knowledge of the rules and the ability to apply those rules almost instantaneously. An appellate judge is looking at things from a different perspective. I think it's more of an introspective analysis rather than a instantaneous kind of decision. There's a lot of resources that you can review prior to issuing the ruling, and so I think obviously it doesn't hurt anything, but I don't know that it necessarily would be a detriment not to have that as an appellate judge.
Thank you.
Any other questions to my left here? How about to my right?
Good morning, Mr. McGuire, and again, thank you for submitting your application. You said that in your practice, you're involved in about 49 of the 50 states. What percentage has been Iowa? Is it the same? Is it more? If you could just speak to your connection in the Iowa courts.
Our Iowa cases are actually fairly small in number. We have, I think, for a couple of reasons. One, we have a tremendous market penetration in Iowa, so I think we insure a large number of pharmacies in Iowa. But we tend to have very conscientious pharmacists, and so I don't think we see as many claims, number one. And then number two, the people of Iowa are not quite as litigious as, say, Philadelphia or or other places. So from a pure number perspective, Iowa is one of our smallest states as far as number of cases.
Any other questions? Professor Cochran?
Mr. McGuire, I have a constitutional question at the intersection of your two interests. Do you think that pharmacists have a free exercise right not to fill prescriptions that they might have a religious objection to?
That's a hot topic, obviously, out in pharmacy. And we just talked about it this weekend. I was at the Iowa Pharmacy Educational Expo. I do think that that's a right of the pharmacist to have a conscientious objection. However, I think you also need to balance that with the rights of the patient, and so that they have the ability to go somewhere else to get that. In most situations, that's possible. There was one example with a patient who came in, has a prescription, and the pharmacist refuses to fill it, but then tears it up, and obviously then leaves the patient kind of hanging at that point. And I think that's gone too far, but I also don't think that you want to make pharmacists do something that they have a legitimate conscientious objection to.
Any other questions on the right? I have a question. You state you do business in 49 different states.
Mhm.
Tell us some of the hazards of litigation in some of those states, and maybe Alabama might be a prime example. Although I've had a case with you, and we did okay.
Yeah.
But tell me what you see the hazards of the other states where judges are elected, and we don't have this process.
Typically in the states where the judges are elected, the biggest contributors are the plaintiff's bar. And we find that even going into a case, our local counsel will say, you might as well settle because you're never going to win. You're never going to get a summary judgment motion in your favor. And so in those states, you end up typically paying a premium for that. Alabama's put through some tort reform. They're not quite as bad as they used to be. Mississippi has put through tort reform. Missouri is probably next on the list that needs to do that. But I think just the reflection of Iowa, the fact that nobody's really talking about tort reform in Iowa, tells you that the system is pretty balanced.
When you talked about earlier in your remarks that you think that there may be some campaigning after the last election, how do you think that may change the way that Iowa businesses such as yourself do business in Iowa?
At this point, with kind of so many unknowns, I don't know that it would change anything. We're an Iowa company. I don't know that we're going to change anything with our business in Iowa. This is kind of our flagship state, so I don't know that that's going to change. I think it's going to probably reflect more on other companies who aren't Iowa companies, who maybe are looking to come to Iowa or to stay in Iowa and things like that. I mean, at this point, I don't know that it's going to come down to some kind of full-blown knuckle busters kind of fight that scares companies out of Iowa. But at this point, as far as our company is concerned, I don't think it will change anything.
Any other questions? Mr. Brody?
Yes, when you're not an attorney, what are your outside interests? What do you spend the other time?
My real life kind of things. I read a lot, mostly nonfiction, history, typically, photography. I love to take landscape, wildlife photos, and right now watching my children's sporting activities, which seems to take up all of my free time.
Any other questions by the panel? Mr. Mickelson?
In the event that you move up to the Supreme Court, do you have thought about advocating any change with the other justices that are on the court, or do you see things need to stay the way they are, or have you thought about that?
Advocating change in what sense?
Procedures, the way things are done, do you like the way things are now?
Generally, I would say I like the way that things are done now. I think I agree with the comment earlier that we need to reach out to the public more so that they understand what it is that we do. And I think, that's something that typically is not normal or comfortable for justices. But as far as procedures, having had some cases come through the system from our company, I wouldn't necessarily recommend any changes to procedures.
How about maybe the length of decisions? Do you have a comment on are they long, are they short, are they just right? Have you thought about that?
I thought you were going to say length as in till they actual ruling.
Well, that too.
We had one case that was quite a while after the hearing, so I would think if you could improve one thing, it would be the speed of the decision being made. As far as the length, I don't know that I would say that they're wrong or too long or too short at this point. The ones that I've read seem to take the requisite time and space to explain what was going on.
Mr. Fitzgibbon?
I know our time's getting short, Mr. McGuire. Thank you for coming here this morning. But you have somewhat of a unique position of many regarding your experience. And as Justice Wiggins indicated in one of his questions, you've worked in a lot of different states. I think you indicated 49 of them. And I would understand that you have a pretty conversant understanding of the legal systems in many of those states. There's a term that we often hear about activist judges. And you're somewhat of a student, certainly, of judging and judges in Supreme Courts and maybe all the states, 49 states of the 50. Do you think we have an activist bench here in Iowa?
Typically, I would say no. my definition of an activist judge, you know, a good judge rules for you and an activist judge rules for the other side. And that's kind of the way that I look at it. But like I said, in some other states that we have had cases in, it's almost a preordained result without the case even being heard.